A Kansas woman, already arrested twice for drunk driving, is now accused of killing a 55-year-old woman in a horrific head-on crash. Prosecutors say she was impaired when she crossed the center line, and court records reveal a disturbing pattern of prior arrests and violated court orders. We're going to break down the tragic details of this case and how it could have been prevented. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This is a tragedy that never should have happened. I want to make that clear. It's one that if lessons had been learned sooner, it might have been entirely preventable. It was Friday, August 8th on K-140 in Saline County, just an ordinary summer drive for 55-year-old Deanna June Sommerfeld and her husband Mark, but in an instant that routine turned to horror. Prosecutors say 32-year-old Kayla Errebo, suspected of driving under the influence, crossed the center line and slammed into them head-on. June was killed, Mark was left badly injured. And by the way, here's the gut punch. This apparently wasn't the first time. Court records show Errebo has been arrested before, twice for drunk driving. In January of 2024, she was charged with DUI and tampering with her court-ordered ignition interlock device. 5 months later, in June, she was arrested again for DUI, fleeing from police, driving without a license, and once again, ignoring her interlock restriction. An interlock device, by the way, is being a breathalyzer that is connected to a vehicle's ignition system, so it prevents the car from starting if a person's breath alcohol concentration exceeds the legal limit. She pled guilty. She got probation. And now, just months before it was set to end, she's accused of taking someone's life. If these allegations are true, this is incredibly infuriating. We talk about in the law foreseeability. What are we talking about? August 12th, Errebo made her first court appearance, where prosecutors reportedly asked for up to $2 million in bond. The judge had set it apparently at $1 million with conditions that if she's released, there's no driving, no contact with victims, an alcohol monitoring device strapped to her. Now, I'm going to walk you through the charges. I'm going to walk you through the criminal history, but I'm not going to do it alone. I want to bring on somebody who has a special expertise in this, criminal defense attorney Eric Faddis. Eric, thank you so much for coming on. So first of all, can you explain what second-degree murder means in a case like this, especially when we're talking about intoxication and recklessness being involved or allegedly being involved?
Yes, Jesse. So this is, of course, an extremely severe charge. And essentially what it alleges is that Errebo was driving with recklessness and with a extreme indifference to human life. And that on this pattern of conduct, this history of drinking and driving. She knew she was doing, she knew that it was problematic and dangerous. She did it anyway. And now we have one person dead, one person seriously injured.
And the defendant, and just to be clear, second degree doesn't mean that there needs to be intent, right? That she wanted to kill anybody, but it is a higher burden. But at the same time, given the allegations here, this could be a clear-cut case of it.
Yeah, exactly. You don't need intent. It's not like intentional first-degree murder, but it is acting with recklessness and with an extreme disregard to human life. And I think prosecutors are going to argue that that's based on, her knowledge of her own substance use, the pattern of conduct over time, and that she's still engaged in this conduct with these ultimately fatal consequences.
By the way, she's also facing aggravated battery and misdemeanor charges. How are those usually handled alongside a serious felony charge like murder?
Well, just in part, they give the prosecution extra leverage because the battery charge is rather significant too. We're talking about causing serious bodily injury to somebody else. On top of that, there is the interlock evasion charge. There's a hit and run charge. There are all of these charges stacking up against Errebo. Her conduct seemed to be escalating. Prosecutors are going to use that in terms of trying to resolve the case if they do extend a plea offer, saying, hey, you've got all of this other exposure on these other charges as well. You better have a come to Jesus talk and take responsibility.
How does the court weigh the fact that this wasn't apparently her first DUI offense in terms of bail, monitoring? Hey, if she gets convicted or pleads guilty, sentencing. This is, aside from the idea of these allegations are true, morally bankrupt. Legally, how problematic is it?
It's scary stuff because what we're talking about, the judge is looking at in terms of bail, the risk to the community. And when you have a repeat offender, allegedly, that obviously is the ante there in terms of that risk. When we're talking about sentencing, we're talking about someone, if convicted, who has never learned on this issue. And in fact, there may have even been a 2022 traffic matter involving alcohol. And so we have these stacking up against her. It is going to be aggravating to the max. And she's looking at 9 to 41 years on the second-degree murder charge.
And by the way, you put that to the side, the seriousness of it. One of the things that we don't talk about enough is this tampering with the court-ordered ignition interlock device. Does that happen a lot? And how seriously do courts treat violations like this?
You know, in Colorado, where I practiced for a long time, that actually had a mandatory minimum jail sentence if you tamper with interlock device. You know, probation is a privilege, not a right. It's an alternative to jail. And really, the defendant has to promise that they're going to agree to these court orders to keep the community safe. When they are evading interlock, which is a court order, they are clearly just sort of flouting these requirements and appearing to not even care about these measures that were put in place to keep the community safe from that defendant's own behavior.
Well, how do people usually interfere with the device?
You know, I've heard of a number of ways. You know, one is just driving a vehicle that doesn't have it. Usually the requirement is that any vehicle you drive has to have the interlock device. But if you take your buddy's car, hey, and you don't get caught, who's going to know? On top of that, sometimes they have someone who is with them, and this sounds crazy, but they will have another person blow into the interlock device, or even I've seen cases where they've asked strangers to try to do that in order to start the ignition in their car and be able to drive. So they will go to serious lengths in order to evade this interlock requirement and drive even as a repeat offender.
By the way, we saw this case. We definitely wanted to bring it to you here on Sidebar. This is an important one to tell. And one of the reasons that we can do that is because of the incredible support that we get from our sponsor, Morgan & Morgan. This is America's largest injury law firm. And honestly, they have an amazing track record. In the past few months, Morgan & Morgan secured a $9.3 million verdict for a car crash victim in Florida, a $5.6 million verdict for another car accident victim in Atlanta, and not to mention $1.8 million in Kentucky after insurance offered them just $5,000 in that case. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks, and everything from signing contracts to uploading documents to talking to your team, it can all be done through the phone. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar. In your experience, what's a defense? What defenses does a criminal attorney explore in a case involving a fatal crash, prior DUIs? What would you mount?
You've got to look at whether there are any mitigating factors. So if I was defense on the case, I would do a complete mental health evaluation. I would look into whether there is any past trauma, any substance abuse within the family that made this person perhaps genetically predisposed. And of course, that's no excuse. That's not some kind of absolute defense to the charges, but it could potentially mitigate those charges and get a better outcome at sentencing. You know, they can always argue that she was not intoxicated. I haven't seen the full reports regarding alcohol concentration and things like that. So there are a few outs to explore. Or
she wasn't the cause of the crash. Or she wasn't the cause of the crash, which could be tough, but...
Yeah, that could be as well. You know, there's always, they have to prove that she was driving. They have to prove she caused the crash. They have to prove she was intoxicated. Can they prove all of those things, especially in a hit and run case? It becomes more difficult.
Let's talk about Miss Errebo, the criminal history of this woman who's, I believe, 33. There were some reports that 32, so 32, 33, Kayla Errebo. It shows a clear and troubling escalation from dangerous driving offenses to allegations of deadly violence. So between January 2024 and August 2025, court filings against her progressed from misdemeanor DUI charges with ignition interlock violations to felony fleeing from police, and ultimately to accusations of homicide and serious assault. Across each case, the pattern repeated: impaired or reckless driving, ignoring court-ordered license restrictions, disregarding legal obligations after collisions, and culminating in allegations of lethal violence. She first apparently landed in legal trouble in January of 2024, where she was charged with multiple counts of driving under the influence. The complaint alleged on or about January 17, 2024, in Saline County, Kansas, Kayla Errebo did unlawfully operate or attempt to operate a vehicle within this state while sustaining an alcohol concentration of at least 0.08 grams of alcohol per 210 liters of breath, as measured within 3 hours of the time of operating or attempting to operate a vehicle, and the offender has a prior conviction for driving under the influence of alcohol and/or drugs, a Class A non-person misdemeanor. Now, the filing lists 2 alternative DUI counts, alleging that she alternatively did unlawfully or attempt to operate a vehicle within this state while under the influence of alcohol to a degree that rendered the offender incapable of safely driving a vehicle, and the offender has a prior conviction for driving under the influence of alcohol and/or drugs, a Class A non-person misdemeanor. Or that she did unlawfully operate or attempt to operate a vehicle within this state while sustaining an alcohol concentration of at least 0.08 grams of alcohol per 210 liters of breath, as shown by any competent evidence, including other competent evidence, and then it says where it's defined, and amendments, and the offender has a prior conviction for driving under the influence of alcohol and/or drugs, a Class A non-person misdemeanor. So she was also charged, by the way, with tampering with her ignition interlock device, and the filing alleges she did unlawfully operate a vehicle not equipped with an ignition interlock device, while such person's driving privileges were restricted to driving a motor vehicle equipped with such device, a Class A non-person misdemeanor, and bond in that case was set at $2,500. She apparently posted it. She was back on the road, and this record shows a clear escalation from misdemeanor DUIs to felony fleeing from police and now homicide allegations. So Eric, how do courts typically view such a progression in assessing risk and culpability? And the other question is, if all of this is true, do we have a problem in our system?
You know, Jesse, it's a very fair question. When courts are looking at these kind of things, they of course see it as aggravating. Look, if it's a first-time offense, a person made a mistake, that's one thing. But when you show a pattern of conduct that is getting worse over time, that is problematic. We're talking about eluding police. You know how dangerous that is, especially if there is a high-speed chase that ensues. It's a danger to everybody, including the police officer, the community, everybody else. And so the court is going to look at that and weigh that heavily in deciding, hey, can this person really be in the community? She has skirted that interlock requirement at least 3 times, fleeing police, disregarding court requirements. It just seems to suggest that she cannot be trusted in the community to act appropriately and be safe.
And by the way, I mean, that hurts her defense to say, we were talking exploring different defenses, it would hurt her defense to say, I wasn't under the influence that day. It's a problem when you look at the history. By the way, that filing lists multiple alternative counts of DUI, so driving with the blood alcohol content over 0.08, impaired to the point of being incapable of safe driving, prior convictions. How do prosecutors decide which charge to pursue in cases like this? Why do they have alternatives?
Yeah, so they have alternatives, Jesse, to kind of wear their belt and suspenders, right? To cover all the bases that could possibly come up. You know, let's say there was a chemical test, but perhaps when you get to trial, there's a problem with that test. Well, there's another way to prove DUI, and it's usually proving that the person was substantially incapable of operating a vehicle safely. And so there are multiple alternative theories the prosecution can utilize in proving this case against her. In case something goes wrong with one theory, they got 2 backups.
Well, let's talk about this, okay? So what was it? Just, I think, 5 months later, Errebo wreaked havoc even more. This time, not only driving under the influence, but also fleeing from an officer, failing to report an accident, driving without a license, and once again, circumventing an ignition interlock device. The June charges also included another DUI count, making it her second arrest for impaired driving in half a year. And according to the criminal complaint, as to count 1, fleeing or attempting to elude a police officer, Prosecutors allege that on June 27, 2024, Errebo, quote, did unlawfully, feloniously, and knowingly fail or refuse to bring the vehicle the offender was driving to a stop or otherwise fled or attempted to elude a pursuing police vehicle, police bicycle when given visual or audible signal to bring the vehicle to a stop, and during the pursuit the offender was involved in a motor vehicle accident or intentionally caused damage to property. Now this charge is severe. It's a level 9 person felony. As to count 2, driving under the influence of alcohol, the filing goes on to allege that she did unlawfully operate or attempt to operate a vehicle within this state while under the influence of alcohol to a degree that rendered the offender incapable of safely driving a vehicle, and the offender has a prior conviction for driving under the influence of alcohol and or drugs. And by the way, this is a Class A non-person misdemeanor. So prosecutors accused her of leaving a vehicle unattended following an accident too. So the filing reads, Kayla Errebo was the driver of a vehicle which collided with or was involved in an accident with another vehicle or other property which was unattended, to wit, 1200 block of South Honeck Road, East Road Ditch, and resulted in any damage to such other vehicle or property, and did unlawfully fail to immediately stop and then and there either locate and notify the operator or owner of such vehicle or other property of such driver's name, address, and the registration number of the vehicle such driver was driving, and or failed to attach securely in a conspicuous place in or on such vehicle or other property. And then the last 2 counts in the filing pertain to driving without a valid driver's license. That's a Class B misdemeanor, tampering with the ignition interlock device. She was released after posting a $6,000 bond, and then in October 2024, she resolved both the January and June cases in plea agreement. In the January case, she pleaded guilty to the DUI charge in exchange for the ignition interlock charge being dismissed. In the June case, she pleaded guilty to fleeing or attempting to elude a police officer and the DUI charge in exchange for dismissal of the failure to report an accident, no valid license, the ignition interlock charges. The court sentenced her to 1 year of probation, so that began on November 15, 2024. It was scheduled to end November 15, 2025. And now we're talking about what we're talking about now. So, Eric, does the fact that she was involved in an accident during the pursuit make this charge even more serious?
Oh, without question. And you look at that January 2024 DUI, at that point, they knew that she engaged in drinking and driving. And then things get taken up a notch. In June 2024, there's a motor vehicle collision in addition to the DUI, in addition to eluding. And then on top of that, we look at August 2025 and we have this fatality. Look, 1 year of probation is kind of a sweetheart deal for Kayla Errebo. That is not something you would likely receive in Colorado, where I practice. Usually you're looking at jail time as a measure of deterrence to try to avoid this kind of thing in the future. As far as I can tell, there was no jail time imposed as a part of the sentence, according to reports. And so perhaps that was a bit of a misstep by the court.
By the way, why are there deals in cases like this? Why is she allowed to plead guilty in certain charges being dismissed and she's only given probation? How is this? Again, we talk about, is there a failure in the system?
One factor oftentimes is caseload. Look, these prosecutors have a ton of cases. I was a former prosecutor myself. I know what it's like to be in those trenches, and you've got, 100 plus cases assigned to you. You've got to focus on the most serious ones. Now, driving under the influence, while problematic, is not always the most serious case you have. However, when you have 2 of them, that should be a red flag. So plea offers are common on these sort of lower level cases like this, but this case exemplifies how that can be a problem and how red flags can go unnoticed and result ultimately in a fatal outcome, such as we have with this case.
And let me get to what we're talking about here. So I think it's important because according to the criminal complaint, as to count 1, murder in the 2nd degree, prosecutors allege that on August 8th, 2025, in Saline County, Kansas, Errebo did unlawfully, feloniously, and unintentionally, but recklessly under circumstances manifesting extreme indifference to the value of human life, kill a human being, Deanna June Sommerfeld. This charge is a severity level 2 person felony. And by the way, Eric, from a legal point of view, to prove an extreme indifference to the value of human life, can they bring up her prior criminal history to show that?
They're certainly going to need to. And sometimes courts are a little reluctant to allow in prior criminal history that is arguably unrelated to the case at hand. Now, that being said, extreme indifference, murder too. One example of that is when a person sort of just like fires a gun into a crowd of people. You're not necessarily intending to kill one specific person, but you're acting with a reckless disregard for human life. They're saying that these actions by Kayla Errebo are tantamount to that. They are equal to someone who just doesn't care about the fact that they very likely could kill somebody, and they act anyway. They're saying that that's what this repeat DUI offender allegedly did.
And real quick, just to go to the count 2 for a second, aggravated battery. So the filing goes on to allege that she did unlawfully, feloniously, and recklessly cause great bodily harm to another person or disfigurement of another person. When we talk about that, because that charge is a severity level 5 person felony, what do we mean by great bodily harm? How do they prove that?
Great bodily harm is something more than pain. It's something more than, scrapes and scratches, something like that. Usually it is the protracted impairment of some function of the body, or it can be a fracture. Like you mentioned, it can be disfigurement, deformity. Even lifelong scars can sometimes qualify in some jurisdictions as serious bodily injury. So it's not just, a little fender bender. It is severely hurting somebody else through one's reckless conduct.
Yeah, just this timeline's crazy. January 2024 DUI, June 2024 fleeing DUI, August 2025 homicide or alleged homicide. This is it's just insane to be thinking about this, and so frustrating as we're talking about, was there a failure of the system? Why does it happen this way? And let's not forget the victim, okay? So as for the victim in this case, Deanna June Sommerfeld, her family is now focused on supporting her loved ones during what is truly a heartbreaking time. A GoFundMe has been set up to help her husband Mark and their 2 young sons, and that GoFundMe reads, "We're trying to raise money for Mark, June's husband." June passed away on August 8th, 2025 in a head-on collision with her husband Mark. She died on the scene. Her husband Mark had to have surgery, is still in the hospital recovering from his injuries. She left behind her husband and her 2 sons. Anything you guys can donate to help this family would be greatly appreciated in this time of grief and healing. When we think about that, we sometimes forget what's left behind here, Eric. And this is a family who now has a new reality. This is devastating. You hope the community and supporters will come out to help them, but my gosh, what do you say to this family? How do they move on?
Oh gosh, the human toll cannot be overstated here. A lot of folks think, oh, drunk driving, I'm having fun, I'm not going to get caught, whatever, it's fine. But these are the real life consequences that can happen, and there's nothing you can give this family that's going to bring that family member back. There's nothing you can say that's really going to give closure or peace of mind in some satisfying way, even if she is sentenced to prison. That is not going to, fill the hole that this person's absence will leave in the hearts of these families.
And according to court records, there is a preliminary hearing in this case. It's scheduled for August 22nd. Pretty straightforward to get this moving, right? I mean, preliminary hearing just to establish there's enough evidence to move forward. I think they probably have that.
It's certainly a low standard at the preliminary hearing, Jesse. They really just have to establish that there's probable cause for the charges, which is significantly lesser burden than proof beyond a reasonable doubt. That being said, in a hit and run charge, sometimes they don't find the person super quickly, and that can cause dissipation of alcohol in one's system. So there could be some hurdles here for the prosecution as well, and they'll have to kind of come with it at that preliminary hearing to make it to the next phase.
Eric Faddis, thank you so much for coming on and breaking it down with me. I really, really appreciate it.
Good to be with you.
All right, so real quick before we wrap things up, I want to let you guys know that I'm actually going to be hosting Cuomo tonight on News Nation, 8 p.m. Eastern. And one of the things I'm going to be doing, or planning to do, if we have enough time, hopefully we can, is take your calls live about any of the true crime cases I've covered here on Sidebar. So if you have an interest, you want to come on live, talk about it, I'm going to put the number in a social media post later today. Hope you can check it out. Really looking forward to it. See you then. And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.